The views expressed on this show by guests and the host on issues outside of the 9/11 controlled demolition evidence are the opinions of those individuals alone and do not necessarily reflect those of architects and engineers for 9/11 Truth.
Welcome, ladies and gentlemen, to another episode of 9/11 Freefall. And this is going to be a big one because AE911Truth is going back to court, and we're prepared to go all the way to the Supreme Court if that is what it takes. Of course, there's a few steps that we got to go through along the way, and we're going to be talking about the next step with our guest today. This is Mick Harrison. He's the litigation director for the Lawyers Committee for 9/11 Inquiry. His practice has involved extensive federal district court and federal appeals work, as well as extensive discovery and motions practices and litigation of virtually every conceivable technical and procedural defense used by agencies and corporations. It's also involved frequent examination of both friendly and hostile witnesses on technical matters, including complex mathematical risk assessments. And he is the guy that has been with us every step of the way, carrying this case forward. He is our Jim Garrison here in the 9/11 Truth movement. But I think we're going to come to a better ending than that movie did, and of course in real life. So let's go ahead and bring Mick on in here. He's going to be filling in all of the gaps that our supporters have been asking us for better than I can. Mick, welcome back to 9/11 Freefall.
Thanks, Andy. Good to be back.
All right, so this has been a long journey. All court cases are, and we haven't covered this case in a while. There's always newcomers jumping on, and there's people who may have forgotten some of the details. So can you please describe how this entire case got started and the steps along the way that have gotten us to this point before we talk about this next step?
Well, it's been a bit of a journey. We being architects and engineers primarily, with my distant advice, filed a request with the National Institute of Standards and Technology, NIST, to correct their World Trade Center 7 report. And most of your listeners will know that that report was essentially a whitewash of the reason for the collapse of Building 7 at the Trade Center on 9/11. And NIST insisted on putting forward publicly the full explanation that fire brought that building down. If you've ever watched that Building 7 fall, it's still available on the video on the web. You can see that it fell rapidly, symmetrically, just like a controlled demolition. And there's no way the scattered fires would have done that. But architects and engineers, to their credit, developed a very meticulous architectural, engineering, scientific analysis of why NIST was wrong in that conclusion and why there had to be essentially the use of explosives to account for the collapse of that building as we all observed it. And in addition to a lot of documented scientific evidence that was not immediately observable at the time. And that was put forward to NIST in a request for correction, which is a procedure allowed for every citizen to an agency which is, in the citizen's view, not using information, particularly scientific information, in a public report or release in a way that has integrity. And I was very impressed with AE's work product there. And I thought it was not just compelling, I thought, as was our petition to the grand jury with the Lawyers Committee some time back, it was actually what we call dispositive, meaning it didn't really leave any room for doubt. Unfortunately, NIST decided to deny that petition, refused to make a correction to its report on Building 7's collapse. And so architects and engineers did the next step, which was an administrative appeal, which again was very well done. And I did advise on that as well. And NIST also denied that administrative appeal, which is what led us to the federal court. and we're now going through the federal court steps one at a time. And the first step was to file a federal court complaint with the U.S. District Court in D.C., the nation's capital, articulating that NIST violated the Administrative Procedures Act, the Information Quality Act, and the National Construction Safety Team Act. And we put forward a very detailed petition. It had a number of architects and engineers as plaintiffs, as well as AE itself, the organization. And it had a number of family members of 9/11 victims as co-plaintiffs. And I was honored to represent that entire group in that district court litigation. The district court, after briefing, decided to grant the government's motion to dismiss, which was a predictable attempt by the government to get this case dismissed on the same grounds procedurally that other 9/11 cases I've been involved in have been dismissed, erroneously in those cases, but more erroneously in this case, on the grounds of lack of standing. And if you want, I can give the short version of what that means.
Actually, that is my next question for you. And I just want to make clear to the audience, I mean, and correct me if I'm wrong, Mick, they have not taken us on the evidence at all. So, any debunkers, naysayers out there who say, oh, it keeps on getting thrown out because you guys are full of, you know the word, then that's not the case. They just want to say that who are we to challenge this? We are nobody. So this gets into standing. Please explain this concept of standing to our audience if they don't know.
Well, it's a hugely important point, Andy, that you make, and you're absolutely correct. There was nothing in this decision that said that architects and engineers for 9/11 Truth was incorrect on the merits, meaning the court did not take on the scientific evidence and did not say that AE was incorrect on the evidence. So that's the first point. What they did take on was standing, which is a legal doctrine, which, if applied properly, has a place in the law, and if applied improperly, in my view, actually works a constitutional deprivation of the right of access to the courts. And I'm sure we'll talk a little more about that as we go on. But the legitimate version of standing comes from the U.S. Constitution, and there's a provision that basically says the federal courts are authorized to take on cases or controversies and decide them, but only authorized to do that. The Constitution, unfortunately, doesn't unpack what that means, cases or controversies. The federal courts have been pretty much all over the map in trying to explain what cases are the courts allowed to take and what cases are they not allowed to take under Article 3 standing. And it basically means, are you a person who has been impacted in some significant way by the government action you're challenging, or it might be a corporate action or an individual wrongdoing, but you have to show the court you have some personal or corporate impact or financial impact that harms you in some way, that gives you a motive, an incentive to litigate the case aggressively. Because, as you may or may not remember, and a lot of your listeners may not have come to grips with yet, our court system is an adversarial one, for better or worse, which means it pits two parties or more against each other, and the court sits as a neutral arbitrator, not as an active investigator or an advocate for the truth. And there are pros and cons to that approach, but it means the court really does rely on the parties who are opposing each other being true adversaries. And in that sense, requiring standing makes sense. You don't want a sham litigation where the parties don't have really different interests. You want folks who really are motivated. Now, why that would lead to 9/11 family members and nonprofits and architects and engineers being dismissed in a case like this is somewhat beyond me. It's not a proper application of the doctrine. I'll pause for a moment to see if you have other questions, and I'll unpack that.
No, please continue. This is of such importance, and that'll lead into my next question. But I think this is so important to understand with this whole concept of standing, because I think American people always thought that they had some kind of say in how their government operates, and certainly that there is a requirement to be accurate by the federal government. That's just an assumption of your average layman. But we've been running into this issue where even other cases where even Bob McIlvaine doesn't have the right to challenge it on the standing issue, even when his son died. So this is fascinating. Please go on.
Well, so the ins and outs of the standing question in this case. So we had to demonstrate to the court that our plaintiffs, 9/11 family members, engineers, architects, and AE as a nonprofit, had an interest in the case sufficient to allow the court to hear the case, meaning that AE would aggressively litigate it. And it seems obvious to most of us on our side of this issue that a court would embrace the motivation of, first of all, the family members of 9/11 victims wanting to get to the truth about what happened on 9/11. But the courts have been stingy on that, and I found it personally a bit offensive that the courts are not respecting the rights of family members to have their cases heard. This is another one of those, unfortunately. But there is a distinction that needs to be made. This is not one of those cases where 9/11 family members will be suing like the family members are suing the Saudis in New York, where they're talking about, actual harm to their family members as their injury to give them standing. In this case, we have a different type of standing that we're asserting, and it's called informational standing, and for AE, organizational standing. And that's because you can have a motive to litigate for more than one reason. You can be impacted financially, you could be impacted because your health has been harmed, you could be impacted by loss of a family member. Those are traditional ways that most folks understand give you the right to be in court, and they do give you the right to be in court. But there's also the doctrine that if you're entitled, any citizen or organization in this country, if you're entitled to information from the government by statute, and you're denied that information, and having that information would benefit you, then you have what's called informational standing. And the other argument we made for standing is organizational standing for AE, and that is not just information based. If the government does something that actually interferes with your nonprofit mission, then you have standing to sue to challenge that action to further your mission and protect your mission. So we put both of those arguments forward in this case. And the reason we said that all of the plaintiffs had informational standing is that the National Construction Safety Team Act actually mandates that NIST issue a public report when there's a building collapse that's what we would call major, where there's either a significant loss of life or the potential for that. NIST is mandated by statute, federal statute, to issue a report, to make it public, and in that report to provide an analysis of the likely technical cause of the building's collapse. And what we asserted in this case is NIST did not do that. They merely pretended to do that. What they did was they issued a whitewash, a false and even fraudulent report that they knew was false, and gave a reason for the collapse of Building 7 on 9/11 that they knew could not be scientifically speaking correct. And for that reason, we argued that all of the plaintiffs were denied information they were entitled to by statute, which is a report from NIST issued publicly that actually gives a good faith, honest analysis of the likely technical cause of Building 7's collapse. And I'll tell you where the court went wrong in that in a moment, but let me give you the short version of why architects and engineers also had organizational standing. And that's because, as you know, and the board knows for AE, their mission is to promote transparency, to promote the truth about what happened with the building collapses so the public can understand what really happened on 9/11. And our AE, to its credit, has been working industriously at much expense over many years to bring that truth out for the public and for the benefit of the family members. And so that's at the heart of AE's nonprofit mission. But what NIST did when it issued this false report on the wrong reason for Building 7's collapse is it interfered with AE's ability to educate the public on the real reason for the building's collapse. And we all know that sometimes the government reports are taken as gospel by a lot of people in the public and particularly in the media. And it can lead, when that happens, it can lead to really a major step backwards in moving the truth forward. And in this case, that means a major step backwards in moving AE's mission forward. So whether or not there was a statutory mandate for NIST to issue that report, and whether or not AE had a right to information by statute, which the court got confused on in this case, even if that was not true, it's still true that NIST issued the report. It's still true that it was knowingly false. And it's still true that it is a major obstacle to AE performing its mission of getting the truth out about those building collapses on 9/11 at the Trade Center, which is why AE spent, I think it's probably approaching $300,000 now to do that study from the University of Alaska with Professor Halsey, which very carefully examined the collapse of Building 7 and reached a very different conclusion than NIST. And so our argument was, and I think it's legally correct, that because AE had to expend an unusually large amount of its limited resources to combat this false NIST report, they have organizational standing because the government actually interfered with its mission and AE had to expend resources to combat that interference. So that was our argument. So do you want to know where the court went wrong on that?
Well, I mean, please go on, because I want to get to the question of exceptional importance. And by the way, there's a little bit of a tapping that I'm hearing. If it's coming through on the broadcast, I apologize. It's like this phantom noise that's haunted my apartment for a few weeks. I can't do anything about it. But we made a video, very short one, where we have a statement from the court on there that we can very accurately interpret the meaning of, but I would rather you talk about it. So please continue. And I have a question though regarding their arguments after you.
All right.
Go on.
So we're sneaking up on the reason why we're filing a petition for rehearing en banc with the entire set of active judges in the U.S. Court of Appeals for the D.C. Circuit in Washington. And the reason is the mistake I'm about to explain to you, or mistakes by the panel of 3 judges. We had 3 judges who reviewed our case at the appellate court after the district court dismissed on standing. The district court decided, and it probably will come as a shock to those who haven't heard it yet, that even if NIST issued a fraudulent report, meaning a knowingly false report on Building 7's collapse, even if that were true, which we did allege was true, that the public still got, and AE still got, and the 9/11 family members still got everything they were entitled to by statute because they got a report, a piece of paper that said report on the collapse of Building 7. And apparently, the court would say, even if it was that single piece of paper with that title on it, we would have gotten what we were entitled to, that a statutory mandate by Congress on an agency, in the court's mind, doesn't really mean that the agency has to do a good faith or even honest job of completing the task that Congress mandates and issuing a report, that a fraudulent report satisfies a mandate from Congress. And I find that shocking. And that's one of the primary reasons we have decided to first appeal to the panel of 3 judges, and the panel of 3 judges, I will tell you, mistakenly adopted that rationale from the district court and is basically saying the same thing, that the public doesn't have a right to honest reports with integrity from federal agencies, even when Congress mandates the report be issued. And that is what underlies the step we are taking. We took a few days ago when we filed our petition for rehearing en banc. And I'll stop there and see where you want to go.
Well, we're going to be making that available in the description of the show for our audience. We've gotten a lot of questions, people wanting to see the documents, and the holidays are coming up. I think some people want to spend that really digging through this. And, we can hear the mental jujitsu that is going on here and all of these arguments about standing. I know there's probably members of our audience who are saying, why do we got to do all of this? It was a controlled demolition. The evidence shows it. Well, these are the hoops that we got to jump through in the legal system. And thank God we have Mick to do it for us. But in reading these arguments made by the court, it is almost like, and you can tell me if this is an accurate comparison or not, it's almost like if you're in school, and unless the teacher, every time he assigns homework, says that the questions have to be correct, unless he puts that little disclaimer each time he assigns homework, that you could basically turn it in with wrong answers and still get an A. That's what the court is saying, that unless Congress says in the legislation that it has to be accurate, that they can get away with essentially saying anything in these reports. Am I accurate in that summation?
I'm afraid you are. To make a long story short, I think that's what the courts have just said, that it doesn't matter what the report says, as long as it's a report. And that's disturbing. I mean, we're supposed to have a system of checks and balances in this country where the judicial branch oversees the executive branch as one of those checks and balances. And if the executive branch or some part of it, an agency, decides to abuse its authority, there's supposed to be a check on that. And the judicial branch is supposed to be a primary check on agency abuse. Congress can do some of it, but that's a very political process, as we've learned. And they haven't actually stepped to the plate fully yet on 9/11. They're waiting for that day. In the meantime, citizens do have a right to access the courts to challenge an improper, illegal, arbitrary agency action. And one of the things we argued to the entire set of judges in the DC Circuit Court of Appeals a few days ago is that when an agency issues a report that's fraudulent, knowingly false, it violates the Administrative Procedures Act per se, which means it's arbitrary and capricious as a matter of law when you have a knowingly false report by an agency. So one of the laws that the judicial branch can use to hold agencies accountable, one of the important ones, is the Administrative Procedures Act, which allows citizens to challenge arbitrary, capricious agency action contrary to law. And we were doing that when we started this lawsuit. So, that homework analogy is a little too accurate there. I used to teach school for 10 years, and I can tell you no teacher would allow that sort of rationale to hold in their classroom. It's a strange thing to see a court doing it, and it's disappointing for me as a member of the bar. And I hope that the entire set of judges in the Court of Appeals in DC will correct it.
Well, it's not even just disappointing, it's terrifying because it just completely undermines the whole system that we think we have in this country. First of all, we're taxpayers, so theoretically we pay for these reports. You don't pay for something that is done in a shoddy manner. You pay for somebody to build a fence and the fence falls down after one day. You want your money back. That's how it works out in the world of commerce. We paid for these reports and we're getting inaccurate reports. We've cited so many times in so many articles and in so many ways, all the inaccuracies. And the NIST report, I wrote one, silver bullets, 4 points that completely just knocked the NIST reports back on their behinds. May have had a different title for that. But this is the central issue behind this entire thing, beyond the 9/11 issue. Now, I still hold that the 9/11 issue is the most important issue in the 21st century. I mean, 3,000 people died that day, many of them in those towers. But just expanding out for any group or advocacy, member, people who advocate on behalf of a scientific issue, one way or the other. You still expect that when the government issues a report that it's doing its best to be accurate. And if there's some information that comes to its attention to show where it wasn't accurate, that it will do its due diligence and change that report. But now we have the government. I mean, forget that the court is ruling this. We have the government hiding behind this. Like going along with this, we don't have to be accurate. I don't see the government doing anything to challenge this ruling on their behalf. They're just happy to get away scot-free. So this is so much bigger than 9/11. This goes into the essence of what America is all about. Does the government answer to the people? And to me, as a layman, it seems like a huge constitutional issue, right up there with some of the big ones that we've talked about in our history classes. I was going to ask you about this later, but I'm going to bring it up now because you're talking about how they're dodging this whole issue of having to be accurate and whether they can issue a fraudulent report. In the petition you filed, where the court says NIST didn't have to issue this accurate report as long as they met statutory requirements, you point out that the court zeroed in on the NCST Act requirements, but basically failed to address the Information Quality Act standards.
Right.
Talk about why that's so important and how that plays into this case.
So I'd like you to do me a favor, Andy, and remember that question, because you raised a point just a moment ago about the major constitutional issue. And if you would allow me, I'd like to say why you're right about that and help folks understand the importance of that constitutional issue. And then let's come back to ignoring the Information Quality Act, which it's an important issue, but not quite as big as the one you first mentioned. And you're right about this constitutional issue being a huge one. I just wanted to explain, particularly for those lawyers who might be listening, why it's so huge. We're really talking about limiting citizens' access to the courts to challenge agency misconduct. And we're inevitably, and in the same breath, talking about why the judiciary is going to be handicapped by this type of ruling in doing its job of overseeing the executive branch and being a check and balance on abuses by the executive branch. And a lot of folks don't understand how this works. If Congress sees an agency doing something wrong, they can sort of start an investigation on their own initiative. Courts cannot do that. Courts are limited by the Constitution and their role. And they have to, as we mentioned, whatever they can do, they have to do it through a case or controversy, reviewing a litigation and deciding it. But what happens if the courts have adopted a doctrine like this one, which keeps citizens who are affected and adversely affected out of court, blocks them from asserting a complaint because of lack of standing? What happens to judicial oversight when that happens? And the answer is nothing happens, because the judiciary cannot correct an agency action unless there's a plaintiff who has standing, who is recognized to have standing, to bring the matter to the court's attention. So the judicial power to do oversight is intimately intertwined with the ability of citizens to demonstrate standing to bring agency misconduct to the court's attention. And if these doctrines of limiting standing are allowed to stand, you're effectively going to have no judicial oversight of the executive branch, which means we're no longer going to have the government of checks and balances that we rely on to protect our Constitution and our democracy, which is why your point is particularly significant. I appreciate your tolerating me in saying that. So let's go back, if you're ready, to the other question, which is one of the errors we alleged is that the court ignored the Information Quality Act requirements, and they did. So what we asserted in our petition for en banc review by the entire DC Circuit, and we had like 5 or 6 different errors, but this one is a significant one, because even if the court, the three judge panel was correct, and they were not correct, but even if they were correct in saying that because NIST issued a report, no matter how wrong it was, no matter how dishonest it was, that satisfied the National Construction Safety Act requirement for releasing a public report, even if the court was right about that. What the court said was in their decision was, because of their reasoning on that we got all we were entitled to, AE got all it was entitled to, which was a fraudulent report, and there was nothing the court could do to order any remedy for AE and the family members and the architects and engineers who were plaintiffs, and that's just wrong. And the reason it's wrong is, even if we accepted for just one moment, for the purpose of argument, that a fraudulent report satisfies the congressional mandate, there was still something the court could do to give us a judicial remedy. They could have ordered compliance with the Information Quality Act requirements, which involve integrity, transparency, reproducibility. I think there are 5 of them. And basically what the IQA, the Information Quality Act, does is it puts into operational principles the concept that an agency shouldn't just be lying to the public and shouldn't even just be blatantly incompetent. There has to be certain standards met in government reports. That's what the IQA is supposed to give us. So even if the court was right that it couldn't do more to order relief on the National Construction Safety Team Act requirement of a public report, it still could have required compliance with all these quality standards for information. And that's what AE did a very nice job of articulating in its request for correction and in its complaint, which is here are all the violations of these standards. Here's what needs to be done to correct them. And the court basically just punted on that.
Well, the question then raises that if the official reports from any agency, because this applies to any agency, doesn't have to be accurate, aren't there members of Congress writing laws based off of agency reports? Let's forget 9/11 for a minute. Let's say that they determine that power lines are causing cancer in a certain area, and some new regulation gets put in based on this official report. Well, how can you make a determination on how the laws should be written if you can't rely on government reports? So there is a lot of things affected by this ruling. It is of super great importance here, not just for us, and that is why we're gonna try to see this through. Because let's get it out in the open. If we do not really have a government of the people for the people, then I want that stated. I want that stated by either the court's refusal to address this issue or some kind of higher up ruling, and then I got plans for how to address that after that. And this is something that I think that we can really make a difference, even if we never got a new investigation of 9/11, even if we never got it acknowledged what really happened at those buildings. I think we will. But even if we didn't, we can still make a huge difference and put a step down for the future, so that something like this can't happen again, that you can't have a major event, have a government just lie about it through their teeth and have people accept it. So if we can actually do something to make a difference and set some new kind of standard, I am all for that. Now, interestingly enough, in this entire back and forth here with the court, in your petition, you write that the panel decision misapprehended the law and conflicts with decisions of the Supreme Court and the circuit. You also cite what the panel said, and I'm going to read it verbatim. But plaintiffs have not been deprived of information. Rather, plaintiffs allege that they have the correct information, and they want a court to order NIST to reissue a report that endorses that information. Talk about the error that's in the panel's logic that you see and wrote in the petition.
Well, the court misapprehended a couple of our positions, or misrepresented a couple of our positions, but they certainly misstated them related to the error you're talking about. One was the court actually said that we conceded that NIST did everything that was required of them because they just issued a report, even though it was fraudulent. And we never said that. We said just the opposite, that the report had to have integrity, had to be honest to satisfy the legal requirements. That was our position. So the court mischaracterized us in that regard. And the other error related to that was the court was basically saying that what we wanted was a report that agreed with us. It wasn't like we were trying to enforce the law. It wasn't like we were trying to require the agency to do something with scientific integrity and to meet objective standards. We just wanted to force the agency to give the conclusion that we had reached, AE had reached through its own. And that's just wrong, because all we asked for in the complaint was compliance with the law and adherence to the objective information quality standards in the IQA, compliance with the congressional mandate to issue a report with integrity, not a dishonest one, about the cause of the collapse of Building 7. So the court was trying to mischaracterize this as if this is simply, we want the agency to do things the way we think it should be done. And that has nothing to do with our complaint.
Well, no. And the thing is, though, I mean, we expect it to be accurate, right?
Right.
This isn't a question like you're so you make a movie, let's say, and one guy does it in one way and another guy would have done it a different way. You can never get consensus with creative stuff. This is a matter of science. If something's wrong and there's observable facts that get ignored, I mean, that's ignoring evidence. In a criminal matter, you ignore evidence, you can get in some serious trouble, or you cover up evidence and you're a cop, you can get in some serious trouble for doing that. And so, I mean, in this matter, when you're investigating what is a crime or it's an aspect of the crime, and they want to say that raging fires, caused the beams framing in the girder to, push it off its seat because of thermal expansion. And then you can look and see pictures and you can see the fires were out in the area of collapse initiation. I mean, that is a pretty big point because you can't have thermal expansion without raging fires. And you can't just ignore that. You can't just say, oh, we stand by our report like NIST does. So it's not a matter of, they didn't do it in the right procedural way that we thought they should have. They're just dead wrong. And it's almost like when you read this, they're interpreting, and I think you cite this in the petition, it's like they're interpreting the Halsey report that we commissioned, and at great expense. People on the staff, had to go through some hardships for us to pay for that, personal ones. It was all hands on deck with that thing. But they're treating this as if we were trying to get information out of it from NIST or something. And you can explain this better than me. When really we were refuting the report, showing why the NIST report was wrong. But please elaborate on that.
Well, that's another good point. It's another central error we articulated in our petition. The court is basically taking the position, and this is the 3-judge panel, that because architects and engineers were so industrious and so dedicated in doing their homework and spending their limited resources to get that Alaska study, the court is now trying to use it against AE on its organizational standing and saying, well, look, you weren't harmed by NIST not giving you the correct scientific information because you got it yourself at your own expense through your own effort. And so what's the problem? You're not uninformed because you've informed yourself. And that's just not the law. Okay. Just because citizens have the competence to do their own investigation doesn't mean that Congress didn't mandate that NIST do a report with integrity. And you made an important point earlier that a false report from NIST doesn't just mislead the public, it misleads Congress. And Congress relies on agencies to inform it. So Congress can make the laws to protect all of our interests. That's the way it's supposed to work. And what happens when an agency gives a false report to Congress? And so that's a harm for all of us, even if we do our own homework. And so the bottom line is the statutory mandate on NIST had nothing to do with what information AE can come up with by its own resources. It has to do with a duty imposed on a federal agency. And that duty doesn't dissipate just because AE is unusually diligent and makes unusual sacrifices to get to the truth. That doesn't change NIST's obligation under the law. That obligation is still there.
Well, and I'm letting my imagination run wild with this, but you can correct me if I get wrong. But Congress, forget Congress, because intelligence agencies issue reports to the president. Mr. President, we believe that the Russians have nukes in Mexico. We advise that you act. Well, what if that's inaccurate? You could start a world war. Right. Yeah. So, I mean, this stretches so far beyond a simple scientific report because, those kinds of reports in that scenario that I just laid out does rely on science. And I can't explain the science behind it, but something like nuclear signatures and things like that. And we did have sham reports going on that led us into a war in Iraq where you had a guy with all these medals on him saying, hey, these are mobile weapons labs here. And it turned out that wasn't quite accurate and a lot of people died. So to say that they did not have to be accurate is a huge deal and a huge acknowledgement of the reality of our system here. Now, I may have seen something at an earlier date where there was an argument made that AE wouldn't exist if NIST hadn't issued these false reports, that somehow we benefit as if I couldn't be doing something else with my life at this time. What do you have to say to that potential argument that may come up?
Well, I think it actually did come up earlier in the case. So I think you probably did actually read it in the
Okay.
pleadings. And it wasn't exactly like you said, but it was pretty close to what you said. And what the court said was, well, NIST in issuing a false report not only didn't harm AE, it actually did AE an organizational favor because it gave them something they could fundraise on and advocate on. Because if they hadn't done that, what would AE be doing to get the truth out? This gave them an opportunity to educate the public on what was wrong. I don't know. I found that to be a very illogical argument, and it was like turning law on its head. It's like if an agency harms you not by not performing its statutory mandate, it actually benefits you. That's like Orwellian doublespeak.
Yeah. Yeah. I mean, they're stretching. They're stretching. And I these kinds of actions, it's like when we did C-SPAN. You don't expect the congressman to say, "Oh, I agree with you. I'm going to launch a new investigation tomorrow." I would like them to, but you don't expect that. What you expect to happen is that they're going to do everything they can to backpedal from this and dodge it. And the audience, that's the key. The audience sees this. They see their government laid bare right in front of them, and they see how big the problem really is. So no matter what happens with this, the fact that they have to rely on these kinds of arguments, this mental jujitsu that Mick is forced to go through, arguing these ridiculous points with the government, goes to show you that they really have no leg to stand on when it comes to the science, because they know they're wrong. They know they're wrong. And we see how they just try to get around this in so many ways, so many forms, try not to even talk about this anymore. They just wanted to go to the dustbin of history, AE911Truth to go away. This paragraph impressed me from the petition. I'm actually going to read it verbatim for our audience, and you can comment on it. It kind of goes back to some of the stuff we've already talked about, but really good to drive home this point. The appeal panel's decision that fraudulent agency reports satisfy statutory mandates and thus do not give rise to informational standing, if allowed to stand, would severely undercut our system of separation of powers and checks and balances, where the judicial branch serves as a meaningful check on abuse of power by executive branch agencies. The judicial branch can only exercise its jurisdiction and power for oversight of agency misconduct if someone has standing to sue to bring the matter before the judiciary. If no one has standing to challenge agency abuses, the judiciary will be powerless to perform its check and balance oversight constitutional role. Now, I think you talked about this a little, but any comments to add on to that?
Well, it explains why this case its importance goes beyond 9/11. And I agree with you as well, Andy, that 9/11 still has a lot of relevance today, 21 years after the fact, 22, whatever it is now. That because, first of all, the perpetrators are still out there. They could commit the crime again, and they may be committing crimes of a different nature still because they haven't been held to account. And the family members still don't have the truth about what happened to their loved ones, which they're entitled to. And if there was government official involvement, and there are a lot of indications that some officials in the government may have been involved, in addition to possibly officials from other governments and possibly folks outside of the government. It may have been a team, a significant team that had planned this for years. Those folks need to be held to account, or we're going to still see this type of interference. I mean, what we're talking about here, I'll get back to your central question in a moment. What we're talking about here historically is one of several historic attempts to change the government of the United States and the path of the United States internationally by use of violence. And in this case, it was violence disguised in terms of who caused it, who contributed to it. And like the anthrax attacks, it was an attempt to assassinate 2 U.S. senators who were slowing down the passage of the Patriot Act. You could go back to the JFK assassination. We like to think we're immune from the use of violence, political violence in this country, but really we're not. We have had a pattern of it. Historically, 9/11 was another event in that sequence. It just appears to be that people are better at disguising it in this country. But so back to your point, which is what happens when we undercut the ability of the judiciary to be a check and balance on the executive branch by keeping citizens from exercising their right of access to the courts. And what happens is you effectively have an authoritarian form of government in the guise of a democracy, because the check and balances aren't working. The executive branch is free to run amok, which is what happens in an authoritarian government. And we're sitting at home thinking we have something that's on paper a democracy, when really it's not functioning that way. And that cuts across every issue of concern that citizens have. It isn't just 9/11 that isn't going to have accountability and transparency. And, we're going to be subject to abuses in every major area of policy and practice of the government, expenditure of resources, the military, medical care, environmental protection, go down the list. The government's going to be free to do what it wants. Government meaning, in this case, the executive branch. And we won't be able to stop it, and the judicial branch won't be able to stop it. And that's a scary thought. And, we need to do what we can to prevent that from going further. And we're trying to do that in this case.
Well, yeah, and it's supposed to be ruled by law. So, I mean, no matter what political party gets into office with whatever agenda that they have, there's still certain things they are not allowed to do, because we have a constitution and laws already set in motion or already in place to prevent that. And of course, too, it's what we said earlier, is that a lot of those laws are based off of agency reports, scientific ones, because science is supposed to be the final line of proof. I mean, in criminal cases, DNA, there's people being convicted based for murders that happened 40 years ago. They got away with it until some kind of DNA evidence comes forward, and they pull them out of their lives and they put them right in prison. So we have to be ruled by law, and you can only do that if you have some kind of standard that you hold our government up to. Otherwise, they could cede any authority over any matters of science whatsoever. Now, you said a comment about, otherwise it's an authoritarian government masquerading as a democracy. There will be people in this audience, and I may join them, who will argue that that's what this is and what it's always been for a very long time. My point on it is like, either we challenge that and get the system to acknowledge that it shouldn't be, that it's not, or we get them to acknowledge that it is and lay it bare for everybody to see. Because the first way to address a problem is to state it truthfully, what we are facing. So I say just accelerate it. Don't let them hide. Get them to admit that this is a dictatorship if that's what they want it to be. I guess a personal question for you. In all your years of practicing law, have you ever seen anything like this with what you are facing and some of the arguments that you are having to deal with and sort of the stonewalling of justice that we're encountering?
It's a good question. It requires some reflective thought, but the short version is I've seen a progression of decisions like this over time. And it seems to me they're getting more blatant over time. And, I actually became a lawyer because of a decision like this, or conduct like this by an agency in an environmental contamination problem in my home community, where the EPA was running amok and disregarding public health. And I saw it again after I became a lawyer, one of my first cases in a childhood cancer cluster case in California, where scientific evidence is being ignored to protect major corporate players at the expense of kids who were developing cancer and dying. And at that point, I came to the conclusion, well, if the government is prepared to poison kids, what are they not prepared to do? And so I started, being more alert to what I call the worst case scenario. When I start looking at it, in all my cases, I start analyzing the evidence from the point of view of what's the worst possible case, because I know the government's capable of a worst case. And I start ruling out the worst case and working down to the next possible worst case until I finally find the explanation that can't be ruled out by the hard evidence. And that's where I focus my investigation and litigation, and where the truth normally lies. A lot of folks aren't willing to embrace the potential worst case because they haven't had their eyes opened yet to just how corrupt the government can be. And unfortunately, I've learned over 31 years that it can be corrupt. It isn't. I will say I've represented a lot of good folks as whistleblowers in the federal government who are not corrupt. unfortunately, they tend to get fired for doing the right thing because other people in the government are corrupt. And so we do have a corruption problem. A lot of folks don't like to talk about that. A lot of lawyers and politicians don't like to use the C word, the corruption word, but it's there. It's been there for a long time, and it's not getting any better. And until, as you say, we call it out and confront it, force it to be dealt with, it's not going to get better. And whether you're right that it's already far progressed or whether it's in the stages of getting worse, the solution is still the same. We have to challenge it. We have to use the courts and science to confront it and let the people know what's happening. And ultimately, it may be up to those who are listening and the people in this country as a group to solve this problem politically. But one way or the other, we can't just be silent about it. There's too much at stake. And it is going to get worse if we don't confront it.
Right. And, in our pursuit of 9/11 justice, we stepped in it. We stepped in an issue even bigger than us right here that affects everybody. And who are we to shun our responsibility to try to stand up for the entirety of the United States, regardless of how they feel about, every citizen feels about the World Trade Center evidence, or they care about it or not. They have a right to have government issue accurate reports, to be accountable to them, because even if they don't care about our issue, something is going to come up that they care about. And let's try to make our country what we're always told it was growing up in grammar school. I just want to make sure that our audience is fully informed and they understand every step along the way. If you did this already, I apologize, but just quickly clarify for our audience what this next step is going to be. What is a petition for rehearing En Banc? That sounds Latin. So I'm going to need you to step in.
En Banc, E-N space B-A-N-C. It basically means in total, every judge, not just a 3-judge panel, but every active judge in the Court of Appeals in Washington, D.C., the Federal Court of Appeals. I think we're talking about, I haven't counted it recently, and it varies with folks who go in senior status and so forth, but it's about 15 judges. And it's a significant step. And not many cases get to be heard by the entire Court of Appeals. We don't know yet whether our petition will be granted. It should be, for the reasons we've been talking about, certainly. And if it is, it would be a major, I think, breakthrough in this effort for 9/11 Truth to get an entire U.S. Court of Appeals, 15 judges or so, to address the case and decide it. And if they do accept the petition and consider the errors we've articulated and agree with us on any one of them, the case could be sent back and should be sent back to the U.S. Court of Appeal, it won't actually go to the panel, it'll go back to the district court, and the district court will be obligated to hear our case on the merits. And we need to think about that for a minute. If we get a remand by getting the panel corrected and standing is recognized, what does that mean? It means our case on the merits gets decided by a U.S. District Court, and for the first time, apparently in history, court will have to deal with the scientific evidence of the collapse of a World Trade Center building on 9/11 and decide whether AE is right about that or not. And that would be hugely significant.
Absolutely. So if this doesn't go our way, and we haven't decided on certain things yet, but what could be some options that we could pursue? This isn't the end necessarily, even if it doesn't go our way.
No, I would hope not. For all the reasons we've discussed, there are 3 major options at least for AE and the citizens of this country to pursue. If the court denies the en banc petition, the normal legal next step would be to petition the last court in our system, the highest court, the U.S. Supreme Court. And AE will have an obligation to go to the U.S. Supreme Court and ask the U.S. Supreme Court to hear this case. And that's a decision AE will have to make once we see what the D.C. Circuit decides. But it's a case that's worthy of the U.S. Supreme Court for the reasons we've been discussing. The issues of, is a knowingly false report from the agency okay? Is it okay to lie to the American people even when Congress is mandated? a report on a question of great importance like this one, that's an issue worthy of the Supreme Court. But the underlying problem, which we discussed, which is denying standing improperly, denies access to the courts to citizens, and denies the judiciary the opportunity to be a check and balance, that is a question worthy of the U.S. Supreme Court. And so that is the next legal option. Now, because there also could be a fix to this problem by Congress, at least for the immediate problem, Congress could, do some amendments to statutes and make clear that citizens have the right to bring an action, that citizens are intended to by Congress to enforce some of these statutes. That could make it more difficult. It doesn't eliminate the constitutional standing question, which courts have to decide, but it can narrow the opportunities for judicial abuse on standing. And the other thing Congress could do would be to hold an investigation as to whether NIST lied to Congress and issued a false report. And if they found that, they could issue a new mandate either to NIST or to an independent commission to give them a real answer to the question, why did Building 7 collapse on 9/11? And that's something Congress should have done a long time ago. AE could petition Congress to do that. Citizens can do it generally. And then the last option is the one we always remains in our possession, which is we could organize as a body of concerned citizens and try to get a political remedy. That's not a solution that AE would do as a nonprofit. It's not a solution that the Lawyers Committee would do as a nonprofit, but citizens retain that right to organize and pursue a political remedy. And there is certainly, fundamental concerns here about the integrity of the government that may warrant that. So those are some basic options. I'm sure there are some fine point alternatives that we could come up with, variations on these themes, but those are the primary options.
Well, I have some plans, but I'm gonna hold them off until we see what happens here. I kind of put them on hold because we got to go through the process. But we got a powerhouse here in the 9/11 Truth movement. This is why we need our supporters standing with us. Thank you for your donations towards this effort. It costs money to do that, but keep on following our bulletins. Of course, we're going to keep everybody informed every step of the way. What's the timeline that we could be looking at on this next step?
Well, we could get a decision tomorrow on the petition. We could get a decision in a few months. That's probably the time range you're looking at. The courts determined that we don't control the timing, and then there's no statute that or rule that imposes a deadline on the court on this petition and the decision on it. But I would expect it could be either very rapid, and if it's a denial, it may well be rapid. If it's more thoughtful, and one of the judges calls for a vote, and they vote to hear it, that may take a little while. And then if they decide to hear the case, they may well call for a new brief from both parties, which will take, a couple months. And they might even call for an oral argument before the entire court, which would be an exciting thing on this issue, to argue these 9/11 issues in front of 15 judges in the second highest court in the country. That could happen. And that could add a few months before they made a decision on the case substantively. So there's a little bit of variation in the timeline.
All right. Well, our supporters have stuck with us this far. They can wait a few more months to see what happens at this next step, but we're not going away. We stepped in the middle of an issue even bigger than us, but we are going to answer the call, and our supporters are going to do that along with us. May you live in interesting times, and we certainly do. And we hope that the interesting part goes in a positive way, not just for our issue, but for America as well. Mick, thank you for carrying this forward, and we'll keep on top of it and bring you back when we have more to say.
Very good, Andy. Thank you for all your efforts, and thank your colleagues.